substantive law, of custody, and then we will walk you through the procedure of a custody case. Okay. So this is a list of things you will find in the manual, and we'll be going through some of those in this presentation. This is a little roadmap of what we're going to talk about in this section, and it kind of, again, what I'm doing is sort of walking you through the law and getting you closer and closer to the courthouse door until you're actually going to file the case, and then we'll walk you through the process of actually initiating a case and what it looks like. All right. So a threshold question for any case is, does DC have jurisdiction? Is DC the right state in which to file a case? We only have one slide on that because we try to screen the cases for jurisdiction. So it's usually not something you have to worry about. But jurisdictional determinations are fact-based, and every once in a while something pops up later that just didn't come out, or someone else raises jurisdiction, even if there is jurisdiction. So we're not going to spend a lot of time on it. There's a much more detailed handout, although I think I kept it to one page, maybe 1.5, in your manual about jurisdiction. But just to alert you to the basic concept, jurisdiction is governed by a law called the Uniform Child Custody Jurisdiction and Enforcement Act, the UCCJEA. The governing principle of the UCCJEA is that only one state at a time can make a custody determination. So, and often the answer is quite clear which state that is. Every once in a while it's a little less clear because of the law and the facts. Again, we pre-screen, so with any luck you won't be confronting jurisdictional issues, and if you do, you can talk to us. For most of your cases, this will be the first time a court has ever made a custody determination, and for that you do what's called an initial jurisdiction analysis. And the basic idea is that if the child has a home state, that's the state with jurisdiction, and home state is defined by the statute, and the thumbnail description is the state the child has lived in for 6 months immediately preceding the filing of the action. Again, I'm oversimplifying because you're really not going to have to deal with this 99.9% of the time. If the child doesn't have a home state, there's a hierarchy of jurisdictional grounds. So you wait and you see if the next jurisdictional ground can be satisfied. If not, then you go to the next one and the next one. If, however, there's been a prior custody determination somewhere else, it doesn't happen a lot, but it happens occasionally. 5 years ago in Pennsylvania, Mom and Dad had a custody case. Now, child is in DC with Grandma. That's actually called a modification. And there's a different jurisdictional analysis. So again, I'm not going to spend time, I know I keep saying I'm not going to spend time on it, and I do spend time on it, but I just want to flag those two important distinctions. If this is the first custody order that's ever been issued, there's one analysis for jurisdiction. If it's not the first one, there's a different analysis. But again, with any luck, we will have gotten all the necessary facts. Nothing will have, escaped our or your prospective client's notice, and we will have pre-screened for jurisdiction. All righty. So that takes us to the question of what custody actually is. What is it that you're litigating about? And this is actually really important because there's an enormous number of, even though the analysis, the core analysis is very simple, in fact, there are many, 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 many options. And so what you'll be doing is working with your client to craft an option that makes sense. It's a very real world kind of assessment. And again, that could be in aid of settlement. It could be, though, also what you're advocating for at trial. So this is what's on the slide now is the basic analysis. This is essentially the statutory definition of custody. It is statutory, and this is the heart of it. There really isn't anything else other than these words that are meaningful. Custody in DC is divided into two parts. One is physical, the other is legal. Physical custody is defined as the child's living arrangements, including residency and visitation. So essentially, there are 365 days a year on the planet Earth. Somebody has a right to have that child with them or to decide where that child is at that moment. That's physical custody. Legal custody is essentially the right to make big decisions about the child. Not the moment-to-moment, what are you going to wear today decisions, or the moment-to-moment decisions that might arise simply because you have the child with you. If the child falls down, you have to take the child to the doctor, whether you have legal custody or not. But it's the right to make big decisions about the child. It is also the right to access the child's records and information. This is really all it says in the statute to define custody. So let's see if we can give you a little more to work with, because that's awfully broad. First, and you'll hear more about this, I want to highlight that one way that's kind of useful to think about custody is that it's really a bundle of rights and responsibilities. And you can divide the bundle up into two big sub-bundles, legal and physical, but you can divide it up into individual sticks and twigs if you want. You don't have to, but you can. So you're allocating custodial rights. When a judge makes an order, a judge is allocating those rights between and among the litigants, among the parties. Even if a third party, a non-parent, gets rights, the parent retains typically some kind of rights, even if it's just visitation. Even if the third party gets all the other marbles, the parent will typically retain some kind of visitation rights. But again, you can divide the bundle up in a lot of different ways. We'll talk about that in a second. So this is not a termination of parental rights. It is simply an allocation of these rights and responsibilities. In addition, custody can always be modified. The court always has the authority to do it. You hear the term permanent custody all the time. You see it in court orders. I even use it, although I try to avoid using it because I think it sends a counterproductive message in litigation. I mean, if I thought it was productive, I'd use the term, but I don't think it is. The court always has the power to modify. Now, there's a legal standard that has to be met. We'll talk about that in a moment, but it's never permanent. Either party can go, any party can go in and move to modify. All right, let's see if there's anything else I wanted to say about the slide, and there's not. Okay, so how can the court allocate this bundle? Well, here's what the statute says. The statute says the court can award sole physical, joint physical, sole legal, joint legal, or any other arrangement that the court determines is in the best interest of the child. That is literally all the statute says. It doesn't define sole, it doesn't define joint, and it doesn't say anything else about this allocation process. But I cannot emphasize too strongly the importance of that provision, any other arrangement that the court determines is in the child's best interest. So let me give you a little more meat to put on these bones so that you can start to think about this. And again, in a way, it will make more sense once you're in a concrete, factual situation. That's when we can really talk to you about how these general words could translate into a real world, custody order. But let me give you some ideas. Sole, let's see. Let's start with legal. Joint legal custody, not really defined, but I would say that if you asked, any random group of domestic relations lawyers, they would probably agree that it means that both parties or anybody who's got joint legal has co-equivalent decision-making power with someone else who's got joint legal. So if I'm grandma and I have joint legal custody with Jen, we both have the right to make big decisions about the child. My view, and I think I'm right about this, and I think this is a consensus view, honestly, is it doesn't mean you have to agree. It just means you both have the same power. And I know that seems like a meaningless distinction, but it can actually matter sometimes strategically, that joint legal sounds like you're giving a lot to the parent, but if they're not really going to exercise it, it might be a concession that your client is comfortable making in settlement. Because if your client can just go ahead and make all the decisions and the parent is not going to interfere, it might work out fine. On the other hand, it might not work out fine, and that's why it's much easier to talk about in a concrete setting. But that's what I think it means, is you both have the same rights to make decisions, but I don't believe it means you need to agree. Obviously, if you don't agree, what's going to happen is you're probably going to be headed back to court and get the judge to make some kind of decision. So that's joint legal. Sole legal, like, the consensus really is that one parent, the person with sole legal, has the right to make the big decisions, not the other party. So let's talk about physical. Joint physical is just not defined. No one knows what it means. No one knows what it means. I suppose if you put someone in thumb screws, they would say it's 50-50 time, but there's just really nothing that defines joint physical. So frankly, I will tell you that if you use that term all by itself, that strikes me as a somewhat high-risk proposition because there's no definition. But again, everything is situation specific. Maybe that will work for your client, but I would think twice before using that term without defining it further. Sole physical is also not defined, but there's more of a consensus that if you just had an order that said sole physical, it probably means the child is living with the person who has sole physical. The other party is going to have visitation rights, but the residence of the child is with the person with sole physical. So those are kind of the consensus views of what joint and sole mean. But again, the heart of this often is any other arrangement the court determines is in the best interest. Sometimes general language will work really well for your client. Sole physical. Also, more and more litigants and lawyers and judges are using other words, and often that's very safe. The meaning is clear enough. So sole physical, primary physical, residential physical. Probably those are pretty safe terms to mean the child lives with that person. So general terms may work fine. Sole physical, reasonable rights of visitation. Sole physical with a basic visitation schedule every other weekend and 4 weeks in the summer, and federal holidays and birthdays and whatever you want to address. But you can micromanage this to within an inch of your life if you want. And often the detail is more connected to physical custody. What are actually going to be the residence and physical arrangements? The same is true, though, for legal custody. You could have very general language, or you could micromanage it in some way in terms of the decision-making process, how decisions are going to be made. It's less typical to see that micromanagement in legal, I think. What you do see, I think, with some frequency in third-party custody cases, maybe more than micromanagement at least, is joint legal with tiebreaker authority to your client, so that if there is active disagreement, you don't have to go back to court or play a game of chicken with the other party. Tiebreaker authority is already built in, and that's not uncommon. So again, typically though, where detail might be helpful, not always, but might be, some degree of detail is in the physical custody arrangements. And again, you can be as specific or as general as you want. There may be one issue that's hypersensitive that has to be hammered out. Sometimes though, general is better. But I mean, if you wanted to be as specific as pick up and drop off on Saturdays at 4 p.m. at the Benning Road Blue Line Metro stop on the northeast corner with the pink backpack with 2 changes of underwear, you could do that. I'm not suggesting you're going to have to, but you could. All right, so that's what you're litigating about, is custody. So now we're going to talk about law that specifically relates to what we call third-party custody. We will be representing a non-parent in these kinds of cases. So there is a statute that governs third-party custody cases. It's called, nobody calls it this, but it is the Safe and Stable Homes for Children and Youth Act. It was enacted in 2007. There were custody cases brought by third parties before 2007, but there was no statute. But now there is. So now, arguably, these proceedings are governed by the statute. And the statutes, somewhat vague, to say the least. And there's really no case law to speak of about it. There's a couple of cases, but not many that interpret it. So let's talk about things that are specific to third-party custody. First, for third-party custody, there is a threshold issue, which is that not all third parties under this statute can file for custody. The third party has to have standing. And when I say they have to have it, it has to be alleged in the complaint. And then, like any factual allegation in a complaint, it's either going to be contested or it's not. If it's not contested, great. If it's contested, it's contested. But it isn't as though you need to sort of walk in with proof when you file your complaint. A complaint is an allegation. It states a cause of action. It alleges facts upon which the cause of action is based. So you do want to have some facts in your head and in the pleading, but you don't have to prove it at the moment you file. So here are the bases for standing. I'm not going to spend a lot of time on them because they are what they are. And again, there's almost nothing that interprets it. So either you will clearly have standing or it'll be a little more of a fight, and we'll help you with that. I mean, we do try to do some screening for basic standing, but again, it's a fact-based determination. Life is complicated, so you never know. If a parent who has been the primary caregiver during the past 3 years consents, then the third party consents to standing, then the third party has standing. If the third party has lived in the same household as the child for the past 6 months and assumed caregiving responsibilities, the plaintiff, the caregiver, your client, has standing. So if your client has been caregiving for this child for at least the past 6 months, they have standing. And then well, it's not really a catch-all, but the third primary basis for standing is that the third party lives with the child, lives with the child now, as on the day of filing, and there are exceptional circumstances. And I call it a catch-all because, again, you don't have to have had a prior caregiving relationship, but you do have to have the child with you today.
Sorry to be silly, but are you, when we talk about standing, are clients always one person?
No. The question is the client always one person? And in fact, probably that's more typical, but it's not impossible that you could be representing co-plaintiffs if you, it could be a married couple. It could actually be a non-married couple if it's grandma and grandma has a longtime partner, but they're not married. They can absolutely do that. You will have to, and we can help you with this a little bit, it's really an ethics issue. When can you represent two people, and what does that retainer agreement have to look like in order to disclose the potential for conflict? It is absolutely possible. Ultimately, you and your firm will have to make your own ethics decisions, but we believe, and we've done it, and pro bono attorneys have done it, have represented both plaintiffs. So legally, it's possible for two people to file. You know, Jane Smith and John Jones, plaintiffs versus parent. Yeah.
And how does that affect standing? Let's say they live in the same household for 2 months and the other live in
Oh.
benefit or...
Such an interesting question. So the question was, both great questions, questions always are, how would that affect standing if one party has standing and the other doesn't? You have hit on possibly one of the only cases that the Court of Appeals has decided on the third party custody statute, in which it was our case, a brother, an adult brother, and a grandmother of a child filed. Parent, I think primary, like mom was deceased, dad was contesting, something like that. The brother clearly had standing. The grandmother, frankly, really, by this wording, did not have standing. The Court of Appeals affirmed an award of joint custody to mom and the brother based on, in my view, zero analysis. If you want to have a good time, read that case, because I don't see an analytical framework they kind of talk about a lot of stuff and then they say kind of affirmed. I don't see an analysis that could give you any guidance, but you can certainly cite that case. And maybe you all will see an analysis that I haven't. I haven't reread the case in a long time, so I should reread it and see if I spot something that I never spotted before. But every time I've reread it, I just don't see an analysis. But there's a case you can cite where it's kind of a I think of it as a coattails situation, but the court doesn't say that. They don't say anything. Welcome to welcome to the Court of Appeals. Okay, so there is one other basis for standing, but you're not, oh yes, more questions, I'm excited.
Yeah, I think under what used to be
Yes.
bullet 1 on your slide, is it that the parent has had primary custody during some period of the last 3 years or the entirety of the last?
I think the consensus of in terms of how the question is for a primary caretaker standing, is it the entire 3 years or at some point in time? I think the consensus interpretation is at some point during the past 3 years was the consenting parent the primary caregiver. But the statute doesn't elaborate on what any of that means. Is it 1 day? Does it mean the child lived with that parent for a day? Nobody knows yet. But it does not mean the entire 3 years. I think pretty much everybody's convinced that it doesn't mean the entire time, but at some point. I think the notion is that a parent who was doing some caregiving should be able to sort of anoint a caregiver to at least have standing. But if a parent hasn't been a primary caregiver, they shouldn't have that much say so. I think that's the policy thinking. Whether you agree with it or not, that I think is the thought, but it doesn't have to be continuous. Yeah.
And I guess unrelated, but for like the second bullet, is it fair to say that standing is not exclusive? Like, is there more than one person that could say they've had caregiving responsibilities?
So the question is, within the second bullet point, is that exclusive? And in fact, it sort of leads to a question as to whether you could have multiple people with standing under any of these. And I think the answer is, yeah, you could. Absolutely. I think so. And we've seen it sometimes. Somebody gets the consent of the parent. There might be what we call competing caregiver cases. One of the people might not be the caregiver at the moment, but they've gotten consent of a parent who satisfies bullet point number 1. But the person with whom the child is actually living has standing under the other bullet point. Exactly. So you're hitting on, the complexities and the ambiguities of the statute, but I think those are the best answers we can give in terms of the wording of the statute, the absence of case law, and a sense of what the policy is that drove the enactment of the statute. All right, anything else about this slide? No. Yes, the basis for standing that you're not going to encounter very often, I think, but it's there, and so we need to alert you, is what's called de facto parent. The basic idea is, with the consent of the parent, possibly both parents, I forget because we don't encounter it very often, you have held yourself out as the parent. And this provision was included originally to address the needs of same-sex couples. But then it was before, the law has evolved such that usually same-sex couples don't need to invoke this. They are married, the child is born in wedlock, they don't need to be a de facto parent. They are actually a parent as defined by law. But you might still encounter it either with same-sex couples or even with different sex couples, because it could apply to any individuals where one is not the biological, not the genetic parent, but has, with the consent of the parent or parents held him or herself, themselves out to be a parent. And what's interesting is if you're a de facto parent, the legal standard is the same as what is applied in a parent versus parent custody case, because you will learn momentarily that the legal standard in a third-party custody case is a little different than it is in a parent versus parent case. And speaking of the legal standard, that's what we're going to talk about next. Actually, I realized the best way, I think it's actually helpful to know what the legal standard is in the parent-parent case to have context for how this is different. The legal standard in a parent versus parent case is the best interest of the child. That's what it is. And the statute has a whole bunch of factors that you consider in parent-parent cases. You might actually want to look at it. It's 16-914. They're instructive in third-party cases, but it's not the law in third-party cases. This is the law in third-party cases. It's kind of a two-prong, two-layer, two-tier standard in third-party custody cases. First, you have to rebut something that has come to be called the parental presumption. And then you have to prove that custody is in the best interest of the child. So let's talk about the parental presumption first. There is a rebuttable presumption that it is in a child's best interest to be in the parent's custody. That's grounded in the Constitution. Some of you younger folks, and maybe some of us older folks, will remember that in constitutional law, you learn that a parent's right to custody is a fundamental constitutional right. Right to care, custody, management, and control of your child is a fundamental constitutional right. So if somebody's trying to take that away from you, there's a higher sort of due process standard that you're entitled to as a parent. And that's what the parental presumption embodies, is that you get extra points as a parent if somebody's trying to take custody away from you. But it's a rebuttable presumption, and it's rebuttable in all kinds of ways. The statute creates 3 grounds. They're incredibly general. There's really no case law on this yet, but third-party custody, I assure you, is granted all the time. Not every time, but lots and lots of times. So it may sound very formidable, but it is not necessarily as formidable as it sounds. Yes?
I know cases settled or no orders.
So the question is, why aren't there more appellate cases? And I can give you some thoughts about that. One, as you say, is cases do actually settle a fair amount in spite of whatever level of contentiousness they start out with. And sometimes they're not contentious. Again, I want to highlight, sometimes we sort of give you, we mention scenarios that are not that common, but we just want to mention them to you so you know about them. It doesn't mean that that's the common case. So a lot of cases do settle. Some cases go to trial. Again, what drives you is what's in what your client wants after you counsel them. But a lot of cases do settle. I'm sorry. The reason I said we feature certain things is I don't want you to think that every case is highly acrimonious. But needless to say, there are going to be defendants who don't want your client to have what she says she wants, at least at first. So lots of cases settle. The other reason why is many people live with the trial court result, even if they weren't happy with it or thought it should be something else. Once the trial judge has spoken, they are not going to go through the appeal process. The other reason is that there are a lot of defendants in these cases who do not have lawyers. And that makes it less likely that they're going to appeal. So I think it's those 3, I would say, are the 3 most important, not important, but the most common reasons why there's not a lot of appellate case law. And also, even though it may seem like a long time, 2007, not that long, but it really is those other reasons, I think.
And are Superior Court orders persuasive or kind of still factors it doesn't matter?
So the question is, are Superior Court orders persuasive? In other words, after trial, the court enters an order. Well, in terms of appealability, like, are they likely to be upheld?
Oh, just like if you find if you have a standing issue.
I misunderstood your question. I'm so sorry. Right, is sort of as authority. Yeah. Are trial court orders persuasive? I think if you can find them, and sometimes they're reported in the Daily Washington Law Reporter. We're also aware of some that have had on some significant issues that are helpful. They're certainly helpful for you in formulating arguments, and I think you can, I don't know, citing them is a little tricky because technically they're not binding, but you can certainly use their reasoning, and I think you might be able to cite it, but of course you would make it clear that it's a trial court opinion and everybody knows it's not binding. So I think on legal issues, there's some value to that, and we tend on certain legal issues that crop up. We may not know every trial court opinion that's ever been issued, but on some of them we tend to kind of be in the loop because of the volume of work we do and the listservs we're on and things, and because of the Daily Washington Law Reporter where trial court opinions are published, that we can, with any luck, alert you, in addition to just walking you through the analysis, alert you if there is a helpful trial court opinion. I'm thinking of one issue right now where there's been a particular legal issue has been interpreted one way for decades, and a trial judge issued a rather lengthy opinion, a motion to get access to certain kinds of arguably confidential information. And she's like, I don't think it's confidential for purposes of this case. And it's clear the judges know about that. And, you know, her reasoning could be very helpful. So a long answer. Now that I understand your question, I hope the answer made sense. All right. So if you want to rebut the parental presumption, this is what the statute says you have to do. You have to show the parents have abandoned the child or are unable to care. Unable to care is a very broad statement. That is, I mean, abandonment may work for you too, but unable to care may well work for you. Custody with a parent is detrimental to the physical or emotional well-being of the child. That, again, very broad, but very a broad umbrella under which you can operate. That it would be detrimental to the child to be in the parent's custody, and then exceptional circumstances, again, completely undefined. So that's the statutory language for rebutting the parental presumption. The court is supposed to make written findings if it is rebutted, if it finds that the parental presumption has been rebutted, and indeed, written findings of fact are really required any time a custody case has gone to trial. The court isn't supposed to just say, I order custody. There's supposed to be written findings of fact and conclusions of law. You might even be drafting them. Will help. Frankly, my view is you want to draft them because the hand that controls the drafting rules the world. But, you know, when the time comes, some judges want to draft their own. You can volunteer anyway. You know, you can decide what's going to work best for you, and we'll help you get through. So that's rebutting the parental presumption. The court still, though, then has to find that custody with your client is in the child's best interest. Frankly, be honest, if you rebutted the parental presumption, chances are good that the court is going to make this finding. Of course, if there's a competing caregiver, you might be in a different situation. Again, that kind of case is not typical, competing caregivers, but it does happen. So these are very common sense factors. I'm not going to belabor them because we have lots of other things to talk about, but they're very common sense. They're very real. You know, if you were a judge, how in heaven's name would you figure out what's best for a child? Looking at the world through the child's point of view, the child's relationships, the child's stability, the child's continuity, the capacity, the judgment, of the adults to parent appropriately. And to the extent feasible, the child's opinion of his or her own best interest. There are materials in your manual. We don't take a lot of time in the training, but we absolutely can help you through this in mentoring. And there are materials in the manual about how the child's viewpoint is shared with the court. The only thing I will tell you is I'll do what I almost never do, which is just leap to the answer without giving you the analysis. Children just don't testify in superior court. And that's because the law gives the court a lot of latitude to if the judge wants to hear from the child directly, to do so in a non-traditional way, which typically means privately with nobody else there. No lawyers, no parties, no nothing. Yes, there are cases There's a whole string of cases that are in your materials that ratify that this is basically okay. It does have to be on the record. There has to be, so the parties could get access to a transcript. Judges used to do this in chambers, but increasingly, because there was a case that said, yeah, you can do it privately, but not secretly. Judges are kind of, coming down. They'll set up a time with everybody. They'll do it in the courtroom because the courtroom has taping, and we'll have a chat. But there may also be other ways to get the child's viewpoint to the judge without the child talking with the judge. And again, though, you will be deciding with your client, do you want the child to talk with the judge or not? There may be pros, there may be cons, it may be clear, it may not be clear, so we can help you, think that through. So this is if the defendant or defendants consent. If there's a settlement, the court must accept it, must put it in a court order, unless the court decides by clear and convincing evidence it's not in the best interest of the child. I have never seen a court try to blow up a settlement, except for one judge who's now retired. Why would a judge blow up a settlement? And frankly, they probably shouldn't, and the standard is very high, so we let you know that the judge could somehow create a context for an evidentiary hearing and find by clear and convincing evidence that a settlement is not in the child's best interest, but that's just not going to happen. The statute does also come up with a path if one parent consents but the other parent doesn't, and depending on how the other parent reacts to the settlement, you might actually, if the other parent is just kind of missing in action, you can still have a settlement with the consent of one parent. So if mom consents but dad just is not paying any attention to the case, you may still be able to have a settled case without having to put on evidence about the father. Consents can be filed with the complaint. That's probably not going to happen in your cases, but it might, but at any time afterwards, or it can be sort of or verbally articulated in open court. So there's something a little different about consents, though, in third-party custody cases, and I made a mistake and I didn't change that first irrevocable because I don't like to use the word irrevocable. There are two kinds of consents in custody cases. Revocable, and I call it non-revocable, which is much better than irrevocable, but you'll see the difference in a moment and why I don't like to use the term irrevocable, because I think it sends the wrong message, an inaccurate message to everybody. If the consent is revocable, the parent can withdraw it at any time, including after the order is entered. And upon filing the consent, the court must set aside the custody order, and the way the consensus view and the way the judges are interpreting the posture of the case at that point is, okay, there's no more order because mom has withdrawn her consent, but the case resumes. The complaint is still pending. The court can enter temporary custody orders. So, but ultimately mom could withdraw her consent, and it sort of rolls back the videotape to the complaint being pending. Non-revocable consent, though, means that if mom wants to modify the order, the legal standard for modification applies. So what that legal standard is substantial and material change in circumstances, and the modification is in the best interest of the child. So again, if it's revocable consent, mom withdraws it, the case resumes, the burden of proof is on the third party, and the legal standard for an initial custody determination, parental presumption, all of that is what you're dealing with. But if it's non-revocable consent, if mom wants to modify in the future, she can file a motion. The burden is on her, though, to prove substantial material change in circumstances and that the modification is in the best interest of the child. So, missing slide. It's in the manual. There's a whole handout about this. I just wanted Well, how do you know whether you have revocable consent or non-revocable consent? There's a handout in the manual about this, and we can walk you through this when the time comes. I want to get through the rest of the presentation. Basically, there's a case that doesn't address it clearly, but kind of suggests what the court should be looking for. The court is looking for an acknowledgement from the parent that they are waiving core procedural rights. A little bit like a guilty plea, but not quite as detailed. So what that is being interpreted as, again, there's not like set language, but it's being interpreted as either a written answer or an oral colloquy in court in which the parent says, I know I had a right to go to trial. I know that if I went to trial, I get the benefit of a presumption that it would be in my best interest, the child's best interest to be in my custody. And I know that if I want to modify it in the future, it's either going to have to be an agreement with the third party or it's up to the court based on substantial material change in circumstances. And that's not really that elaborate. It's when you get down to it in writing or verbally, it's kind of like you realize you're giving up the right to trial, and in the future, it's going to be up to the judge whether to change custody or not. So that's what makes it non-revocable. And if you don't have that, it's revocable. Revocable is not always a bad thing. I just want to highlight that. You think, oh my God, she can revoke consent at will, but yeah, if she revokes it in 6 months or a year, the child has been with your client 6 months or a year longer. But again, it's very situation specific. We can, help you think about, I think you'll see the pros and cons immediately when you have facts, but we can help you walk through that. Okay. So now we are going to walk you through the procedure of filing a case. That's the substantive law, and we will walk you through filing a case, which is really not super complicated because these are basic notice pleadings. You can do advocacy in the pleading as you want. A written pleading is always an opportunity to do advocacy, but they can also be very bare bones complaints, like de minimis, minimal allegations. And, keep in mind, the other side's going to see it. Sometimes, as with any, it's strategic thinking, and your client is going to be very valuable in figuring out strategy. Will it intimidate? Will the parent realize, ooh, they can say all these, prove all these things about me in court, and so I'm going to back off? Or will the parent get angry that all these negative things are being said in the complaint and, for a while dig her heels in? So again, we can help you think that through. Your client will be very valuable in deciding, but I just want you to know you can do written advocacy, but it is probably more common to have not quite as elaborate complaints where you put out every single negative fact about parents. It's much more common to have somewhat more basic pleadings. Okay. So there's more information in the manual, but if you're filing for the very first time, you initiate the case by filing a complaint. If, however, let's say there was already a case between the parents, and we, with any luck, will usually have found that out if the case was D, you will probably be filing a motion to intervene. You could do it either way, but it's frankly a little more efficient to file a motion to intervene in the old parent versus parent custody case, but you could file a separate complaint. We'll help you figure out what you want to do. It's going to be a motion to intervene. The clerk's office will prepare a summons. You used to have to fill it out yourself, but it's a form. Now the clerk's office is going to fill it out for you. There is this little form called the Family Court Cross-Reference Form. It asks for some basic information about the parties. You do not have to dig up this information. Whatever your client has in the moment, she's got. If she doesn't have it, leave it blank. It goes into the court's database. They want this for a variety of record-keeping reasons, and it's not that important a form. So, complaint, summons, family court cross-reference form. Some practice pointers for life in DC family court. In the complaint, you have to put an address in the caption for each party, even if you don't know the defendant's address. It is perfectly okay to put the last known address and just write last known address. That's absolutely perfectly okay. Even if the last known address is with your, like mom was living with your client, even if you're not sure, if your client's like, I think it was on Benning Road, maybe it was 4200, put it in, because no one really expects your client to know the accurate address, and the signal that it may not be accurate is last known. Perfectly okay. You will have to serve all the parties. We'll talk about that in a second. If the identity of a parent is unknown to your client, typically, let's face it, that's dad. We don't know who the father is. Do not list that person in the caption. Just say in the complaint, paternity is unknown. Just a heads up, although the law does not require it, some judges want birth certificates for the children. It does not have to be filed with the complaint. You can if you want. You may never have to produce it, but we just feel we need to mention it. Sorry, been battling this for years. For some deceased parents, judges, testimony is enough to convict people of homicide. I don't know why some judges want more, but some judges may want either a death certificate or even a newspaper notice or the program from the funeral. Again, don't worry about it. You'll have more than enough time to figure all of that out, see if you have one of those judges, but it happens. Okay, filing. So you've written your complaint, you filled out the family court cross-reference form. There are filing fees in Superior Court, $80 for a complaint, $20 for motions. Your client may well be eligible for a fee waiver, eligible to proceed in form of pauperous. There is a court form that you must use for this. For most pleadings, you're not required to use court forms. There may be some forms that have been developed for people without lawyers, things like that. But this, you actually have to use the court form. And again, there's more information in the manual, and we will walk you through this when you actually have a case. But you actually get the IFP application approved before you file a case. You go directly to a judge called Judge Chambers. You don't actually see the judge. You hand the paperwork to the clerk. They give it to the judge rules on the papers. You get the papers back. Then you go file your case. And you don't need documentation of the data that goes in the IFP. The way IFP works, receipt of certain public benefits makes you automatically eligible, and you just check that box. Otherwise, they want a summary of your financial situation. They do not require documentation. Frankly, I don't think they want documentation. And if your fee waiver is disapproved and you disagree, you can always try again. But it's usually a pretty simple process. And if you're not automatically eligible because of the receipt of public benefits, it's discretionary with the court. There's not really a legal standard for eligibility for a fee waiver. So you are now at the Family Court Central Intake Center, which is part of the Family Court Clerk's Office. It's actually a gigantic counter at the end of the hall on the John Marshall level of court. It looks like the check-in to a hotel, tastefully appointed in purple and lime green. You will hand them your paperwork. They'll process it. They'll give you a case number. They'll give you the processed paperwork back with a case number. What they're also going to give you is a completed summons, which is a notice document to the defendants. And sometimes I say defendant and sometimes I say defendants because, again, in some cases you will have an identified father, and in some cases you won't. They're also going to hand you 2 initial hearing notices, one for you and one to serve on the defendant with the other paperwork. The initial hearing notice tells you what judge your case has been assigned to, the date of your initial status hearing, the time, and the courtroom. If you're filing a motion to intervene instead of a complaint, your case will be scheduled up a little differently, and we'll talk to you about that. Okay. Be aware that the judges are supposed to do the following, and they usually will. At the initial status hearing, they will schedule what are called PAC dates. And that One of those dates is a large group parent education seminar, just one morning, to try to educate parents and caregivers about the harm that custody conflicts can have on children. Typically now, I think they're sending each party to separate sessions, even though they're a large group. But if you want to be sure that they're separate sessions, just make sure that they're separate. The judge will send them to separate sessions. And then they are going to send you, sorry, it was on this slide. They're also going to schedule a date for separate mediation intakes. The point of this process is to try to get people to understand the potential impact on a child of a custody dispute, and frankly, the not so hidden agenda is to encourage people to settle by saying, we really want you to go to mediation, go do a mediation intake. Technically, I think parties are directed to do all of this. Up till now, no one's ever been sanctioned for not doing it, but you will look better or worse depending on when you do it. And mediation can be productive. The court has a mediation office. It's called the Multi-Door Dispute Resolution branch. It is free, it is confidential, and it can be productive. So that's kind of the short take on mediation. If there are domestic violence issues between your client and the other party, again, you can address that with the judge in terms of scheduling. It can also be addressed in terms of mediation. They don't have to be in the same room. And of course, if there's a consent at any point, they're not even going to have to even think about doing this. Okay, let's talk about service of process. So you filed your case, you got the copy of the complaint, the summons, and the initial hearing notice. The burden to serve the defendant is on you, the plaintiff, or the moving party in a motion to intervene. And they've got to be served with these things. You have 60 days to file proof of service, but you can get the time extended on motion. Either a written motion, or if your status hearing is before the expiration of the 60 days, you can make an oral motion. The court will typically entertain an oral motion. And just be sure the record is clear that you got that extension of time. By the way, the court rules that govern, I meant to say this before, it was written in my notes. The court rules that govern custody cases are the DC Superior Court domestic relations rules, not the DC Superior Court civil rules. Our court has very separate rules for different divisions of the court, and domestic relations cases have their own rules. In addition, I'm just going to mention that a whole new set of rules was adopted were promulgated by the court in November of 2018. Some things didn't change, some things did change. In some ways, you don't have to worry about it. Just be aware that if, God forbid, you ever have to research anything that is a rules-based issue, things might have changed. But again, we'll be helping you along with all of that. It's not going to be an issue. Read the rules will tell you what to do. But some of them are kind of new. And the main rule that governs service of complaints is Domestic Relations Rule 4. And even motions to intervene and modify will probably have to be served the same way. I won't bore you with why, but they probably will. Basic methods of service. You can read the rule. It's kind of basic civil procedure that we maybe remember from law school. Personal service on the defendant or a person of suitable age and discretion who resides at the defendant's usual dwelling place. Any adult can serve process, but not the plaintiff herself. So it could be a friend, a family member, a process server, someone who works at the firm, somebody you hire, whatever. So that's valid service. Certified mail return receipt requested. Signature mail. Got to be signed by the defendant or a person of suitable age and discretion residing with the defendant. Let me go back and mention that for personal service, you can serve the defendant anywhere you can find him or her. Joe's Bar and Grill, the DC jail, wherever. But if it's someone else who received it, it's got to be at the dwelling place. This is brand new, first-class mail with acknowledgement. I don't think this is going to bear fruit in most of your cases, but it's something that's becoming more a part of civil practice these days, which is if you send the paperwork to the other side, as provided by the rule, they're supposed to sign an acknowledgement and send the acknowledgement back to you in a self-addressed envelope, and that's valid service. I don't think that's going to happen very often, but you never know. It might. It's new. We haven't tried it very much. Other possibilities, but these are on motion. You have to file a motion and get leave of court. Constructive service. If essentially the other side cannot be found after reasonable efforts to locate, diligent efforts to locate, or if they are evading service, the court can authorize service by publication or posting. This is done on the papers by affidavit. So your client can do an affidavit, you and your people can do searches. It's all stuff you all can do. It's not like you have to hire a private detective. Like, we do these searches all the time. And there's some, materials about, and we can help you think about if constructive service seems to be in your future, what kinds of things are you going to need to do? But it's very, very doable. And it's not uncommon that there is a parent who is kind of missing in action, unlocatable. They may be around out there somewhere, but you either have no idea where they are or they are just unlocatable. So we will walk you through that. Service by alternative means is new in the November 2018 rules. And it's kind of up for grabs. The rule gives some examples. I think the idea is, again, that probably you do need to, well, the rule actually says you need to have tried to effect personal service, but if you can't, the court can authorize some other means, not just publication or posting in the courthouse, but electronic means, leaving it with the employer. They sort of give some examples, but it's very open-ended at this point. So I think it's an interesting area for advocacy to think about how to do that. It's brand new. Okay. Oh, yes.
Service by alternative, should you do that kind of after the 60 days? Like, trying for 60 days, or can you do that pretty quickly and make it?
It's really, so the question is sort of, when do you do this? When do you file these motions for some other kind of service? And I think it really depends on the kind of strategic issues in your case, because it is possible to file a motion for some kind of constructive service or alternate service with the complaint. You can do that. I've done it. But it's probably a little more typical to file the case, try to serve people, send things by regular mail or certified mail to some last known address, get it back. And that's probably going to be the kind of thing you need to do. But you can certainly start looking for people ahead of time. Depending on the situation, maybe you can gin up enough information to file a motion, but the more common scenario is you don't file the motion until after you file the case. And then part of your diligent efforts are, okay, I've actually mailed this, to the last known address and got it back, returned to sender. Does that make sense? Yeah. You do have to file written proof of service. That's an absolute requirement. This is a little schematic that shows you, sort of how to do it. It's kind of common sense. That essentially the individual who served has to sign an affidavit that service was effected. So depending on who served, if it's personal, it's the process, it's whoever handed it. If it's by mail, you can mail. Mail is different from hand delivery. You can mail. Posting, if notice is posted in the courthouse, the court staff will take care of it. By the way, posting and publication are alternatives for each other. Publication is ordered unless you show financial hardship, and then they'll post. And if your client already got a fee waiver, that's all you have to do is basically say that. Otherwise, you have to put something in your motion that says, hi, we can't afford publication, we need to post. Again, we'll walk you through all of that. It's actually a pretty simple process. If it is published, though, the newspaper will mail you an affidavit. Okay, we're in the home stretch. After service is effected, the defendant has 21 days to file an answer. The answer might admit and consent or deny and contest. And yeah, it's often an answer and counterclaim. Although a parent doesn't really need to file a counterclaim. So next steps. So you will recall that when you filed the complaint, an initial hearing was set. It's a status hearing. So what happens, it really depends on where things are at in the case. The court is starting to get oriented. So for example, if you haven't even gotten the other side served, fine. You'll tell the court that, and they'll set another date. But something may have happened where, you know, it helps the court plan. It helps with your input, like, oh, you already served, but the time to answer hasn't expired. What do we do? Has the parent showed up for the initial hearing? If so, the court might try to get oriented a little more about what the battleground is about the case, you know, get a little notion of what the heck is going on here, set the PAC dates. It is possible to make oral requests at status hearings, and the court might well decide them for temporary custody, for what's called a home study, or a forensic custody evaluation, or a guardian ad litem. There are more materials about that in your manual, and other folks will talk about those services that are available. Nobody may ask for them at any status hearing. Somebody may ask for them. The court might do it sua sponte. You might do it at a later status hearing. But these are things that are available that you could ask for, that another party might ask for, or that the court might order sua sponte. I will take this moment, even as we approach the end, to mention, because I mentioned oral motions, family court is a very interesting place. This is a practice pointer. Family court can be more informal than other cases, although frankly in our court, even other cases can get informal. What do I mean by informal? Well, don't motions have to be in writing? Isn't that what the rules say? Well, yeah, except judges rule on oral motions all the time. Rules of evidence? Yeah, they apply, except when a judge decides that they don't. So here's the best advice I can give you. We'll help you identify moments where informality may take hold. If you want more formality, advocate for it and justify it. And you often can. If informality is working for you, and it might, go with it. That's my practice pointer. So, you'll have the initial hearing. It is very common that you don't go directly to trial, that you will want another status hearing or two, the court might. Everything that happens from the initial hearing on, you have input on. So when I say the judge decides, yeah, the judge decides, but you get to advocate. If you want to go directly to trial, ask to go directly to trial. Chances are you won't. I'll be honest, that you're going to want some time to get situated, possibly explore a settlement, you might want to get a temporary custody order in place, but it might be strategically advantageous to say, Your Honor, the next date should be a trial date. Many judges before trial set a pre-trial hearing, which is sometimes 5 minutes, just another status. Sometimes it's a little more elaborate. If there are lawyers on the other side, which there often aren't, but there might be, they might want a little more detailed pretrial statement. Otherwise, it's fairly common to ask for an exchange of witness and exhibit lists. Now, again, they're just trying to kind of tee the case up for trial and be a little more fair. You know, in civil litigation, pretrial procedure can be a lot more elaborate. It tends not to be as elaborate, but again, the judge will give you guidance about the level of elaborateness that they want to engage in, and it typically isn't that elaborate. It's, again, a little bit of an attempt to iron out any logistical issues, be a little bit fairer in terms of exchanging witness and exhibit lists. I know I'm out of time, but we're almost done. You know, these good questions. I'll blame you all. I do want to mention defaults. When a party is served, but no answer is filed, that party technically is in default. And the case can proceed anyway, But there's one form you have to file. You're not actually required to use the court form, but there is a court form, and I absolutely recommend that you use it. You want to be a horse and not a zebra. It's a very simple form. It basically says to the court, yeah, the person's in default. We served them. They filed they didn't file an answer. Like, they already know that. The court already knows that. You have to tell them. And your client has to state in good faith whether your client thinks this person is in the military or not, and that's a requirement of federal law. And typically, your client will be able to say in a sentence or two sufficiently why this person is probably not in the military. After a default is entered, the court can then make a merits determination, and the court will do that. If the defendant who's in default is the only defendant, that's all you have to worry about. If there are two defendants and only one is in default, you still want to file that default form, because that's what frees the court vis-a-vis that parent. And then when you're in a posture, when the case is ripe for a decision as to the other parent, the court will be free to make the ultimate custody determination. Yeah.
There's only one default, one determination. It's not like administrative default by the clerk's office. The judge does it.
Yeah, right. Here's what the default procedure, either the clerk's office or the judge can do it. But the typical procedure, you do have to file that form no matter what, but the clerk's office can enter the default. So if the 21 days passes between court hearings, go file that form, and the clerk will enter the default, and then that default will be on record, and plans can be made accordingly. But if for some reason you have a court hearing on the 22nd day, you can file the form on the 22nd day, and the judge can enter the default. Even in default situations, the judge is typically going to want a brief presentation of evidence. I will mention, however, that if a pro se defendant doesn't file an answer, but shows up in court, our judges increasingly are not going to hold, I have to be honest, not going to hold a pro se defendant's feet to the fire to actually file an answer. Occasionally they will, and if you want to try to get a judge to do that, you can. But typically, even though the rule doesn't say, by the way, if you show up, you don't have to file an answer, for pro se litigants, judges are probably going to let that. They'll treat the case then as being in a contested posture. But your case can go forward. That's fine. You can have a trial. And if the parent never shows up in court again, great. Okay. So we talked about the default already a little bit. And again, we've talked about trials. If the case doesn't settle, and again, even if everybody defaults, you'll have a brief presentation of evidence, but it probably will not have to be, the Microsoft antitrust case. But if it's contested, it's contested. Discovery, standard civil discovery is available in these cases, but we'll talk to you about whether every bone in a lawyer's body wants to do discovery, but against pro se litigants, there may be actually reasons why it's either not productive or you don't want to do it. And again, we can help you strategically. But there will be a trial. The court will issue an order, and we talked about the fact that orders are not really permanent. We talked already about the modification standard, so we don't have to talk about that again, which is good. Yes.
How long approximately the party coming to your office to getting an order or settlement?
Oh golly, how long does it take? That is so idiosyncratic. Let me give you the best answer I can. In a regular case where, you file your complaint, you have to get people served. The initial hearing is scheduled from anywhere from 30 to 60 days from filing, although if you want it sooner, you can file a motion to try to advance it. After that, it really depends. But what I can tell you, which I think is kind of what you're aiming at. So the reason I can't tell you is it depends on how quickly you get service, but usually that's not a particularly long drawn out process. If you have to have constructive service, that adds typically another roughly month and a half because it has to be posted or published for a particular period of time. When you get to the point where the judge can set a trial date, it really depends on how backed up the judge is, but typically they'll, if you come in for a status hearing, whenever you have a hearing, they set the next hearing date, either a status, a motions hearing, a trial. Typically, I would say, all other things being equal, if you're in court and the judge is like, all right, what's my next available date? I mean, you can press hard on that to have it either be shorter or longer. they're finding trial dates in 30 to 60 days from the status hearing at which you ask for a trial date. Now, that's not always true. Every once in a while, they're just a lot more backed up, and it's more like 2.5, 3 months. But I'd say that's typical. So that's the best answer I can give you. Yeah, it can get backed up, but not like civil litigation. Civil litigation, you don't get your initial hearing for 6 months. You don't have trial for 2 years. No, we're talking, much, much dramatically shorter than that. I'm not going to say there aren't cases that go on, but typically not just because the judge is backed up. It's more because you actually want that time to maneuver, to let things settle down. It makes your case stronger. You actually see room for settlement. Yeah, but you don't have, you're not signing away the rest of your life at all. No. Because it's not critical, even though it's informative. I'm going to skip the rest of the slides so we can get to our next presenter, and then you can have lunch on time and get out of here on time. But we have some resources that are kind of helpful to know about sometimes for caregivers. The most important one you'll see in the slides is the Grandparent Subsidy Program. Most caregivers know what kind of public benefits are available for them to help raise the child. But this is a program that senior citizens, I mean, you don't have to be that old, but if you're a great aunt, a grandparent, that they may be eligible for to get some help. You'll see a slide about something called a custodial power of attorney, which is something that a parent can sign without a court order to delegate custodial authority to a caregiver. So there's just some things that in an occasional case might be helpful to know about, and will help you spot the times that they will. So thank you for listening. Thank you for the great questions, and thank you for being willing to do these cases. They're really very, very rewarding. You'll enjoy them.